when you make something completely illegal, when you have prohibition like we have for marijuana, what ends up happening is that there's a thriving black market in this product, and it becomes easier for people to get it illicitly. It becomes easier for people to get it when they're underage or something like that. And so I try to attack it from a bit of a different angle, I suppose.
Yeah, I think you're right, Representative Irwin, because, one of the numbers that people can look at is like, and of course the accusations have been made against us that we're a danger on the highway. Most people would be surprised that the number of arrests for DUI has plummeted since this law was implemented across the board.
Really?
Yes. And see, that's huge, because when you say that we're a danger and this law is being so widely used and abused, you would think that people were just getting blown out of their mind and jumping in their car and driving down the highway at 170 miles an hour. But the facts are, the numbers are this. The number has plummeted. The number of arrests for DUI has plummeted in this state.
Gersh, wait a minute. No, it's plummeted. There's been no studies. I'm sorry.
Yes, there has.
No in Michigan. In Michigan.
I'm talking Colorado. Colorado.
I think that's a Colorado study.
Okay, I may be wrong. Okay.
No, you are. This is a Michigan study. This is right out of the Bureau of Statistics for Michigan.
Okay, that's new information then. Okay, that's cool.
Yep, it's going to be part of our position paper. We've got the number 2010. The numbers as of 2010 have plummeted, and we've got 6 months of 2011, and the trend is down. So what? Maybe that's saying that this medical marijuana, people might be drinking less.
Well, there's a definitive study out of Colorado that indicates that DUIs have gone down. That's factual. I'm not sure the Representative Cavanagh knows that, but it's really true, and I suspect that's also correct in Michigan.
So what we really need to
I agree.
What we really need to do is start separating the rhetoric from the fact, and it might even be smart for us to sit down and re-talk this thing, because I think so much rhetoric has been interjected to the debate. If we go into debate right now, we go into hearings right now, we're going to spend those entire hearings rebutting rhetoric, when we could sit down in 10 minutes and go through the numbers and see what's rhetoric and what's fact, and then we could start formulating a plan to make the law work. And I think that's...
I would differ. There may be rhetoric by various representatives, but the message that Rep. Horn and I are going to convey is a pretty educated message. That, I have been very enlightened over the last 6 months. And I say, I was kind of surprised at the number of DUIs because I didn't necessarily think there was a correlation with alcohol. That's the only reason why I said really. And that's a very positive thing. If medical marijuana is decreasing alcohol use, that's so much better in my mind.
Well, those numbers also include people who are pulled over for medical marijuana usage.
Sure.
With so many people having their cards, you would think if there was a problem, a widespread problem, worthy of legislative action, that it would be reflected in the numbers. And that's what we're seeing. When we're going through these numbers, what we're seeing is either there's absolutely no correlation between the law and the numbers, or the numbers are actually nosediving. So, when you would expect them, if there was a problem, for those numbers to be trending up. So that's what concerns us. Why are we legislating at this point when the numbers say that we shouldn't be doing anything other than implementing the law? And that's our position. It always has been.
And something else I would even suggest there, I don't know if you've heard of this, but there is a existing law in Michigan which is having any presence of a controlled substance in your bloodstream. It's a crime, and I'm talking about if a patient who has ingested cannabis even as long as 12, 15 hours, 24 hours before, may have a low number of 1, 2, 3, 4 nanograms of THC, an active ingredient in their blood, having absolutely no psychotropic effect at all. Will not impair them in any way, shape, or form, but in fact would be an active ingredient of THC, making it a crime as it exists on the books right now. The Michigan Medical Marijuana Act suggests, it states specifically that you can ingest cannabis, but you can't be impaired in operating heavy equipment or using a vehicle. And it also says that any law that's in conflict with the Michigan Medical Marijuana Act is trumped by the Michigan Medical Marijuana Act. But any presence is a problem. And if one of the things, I don't know if this is contemplated, but there needs to be some way to protect the patients, because it's not an impaired level. It's a level that is, and I know this from a trial that I had experts come in and testify. We state lab, and the reality is that the levels of that 8, 10, 12 in someone's body is where the therapeutic and palliative relief comes from, and that's the level that it stays at for the longest period of time in one's bloodstream. And that is what is a misdemeanor crime, could be a felony if someone's got a prior, and it's just part of the patient. It doesn't contemplate anything to do with the patient's health or safety. Can we do something about that?
Well, there has been discussion, and there's no necessarily answer at this point. Changing the mindset is what I'd like to do, but there is talk about prospective legislation. Is it on the table right now? No. But the discussions over the last 6 months has led to a lot of problems that I would like to see corrected. And I don't necessarily know what Chairman Walsh said last week, but he is not just looking at this set of bills. He would like to correct some of these issues.
Without these bills, you're saying, with some other.
Tell the state to obey the law.
Well, the fact that THC does linger longer, yet, you're not impaired. That has been brought to our attention.
Right. That just being in your bloodstream is a crime. And I'll tell you, there was a judge who out of Troy who ruled in a case that by virtue of the voters stating that cannabis or marijuana has medical value, is no longer a Schedule I substance, and therefore the crime of any presence or zero tolerance is invalidated by virtue of the Michigan Medical Marijuana Act.
Well, even more than that, I felt that there was actual wording in the Michigan Medical Marijuana Act that would have made the any presence law null and void because it comes into conflict.
Yeah, but no one's looking at that. But for other reasons. But it's easy for a judge. As lawyers, we can understand this. It's easy for a judge to dismiss a case when there's no real bad behavior. It's just something in the blood. It's an easy, but it still takes a lot of.
If we want to treat cannabis as medicine, it needs to be treated as other medicines in the impairment and driving area. And right now it isn't. It's treated as a Schedule I controlled substance, and it's treated under the zero tolerance. Is that? I feel that there's an interaction between the Michigan Medical Marijuana Act and the laws that were already on the books pertaining to cannabis with respect to patients. Would you agree? Either of you?
I would, and I believe that the Medical Marijuana Act trumps this stuff, like you have pointed out. So do we need legislation to point that out, or, a good lawyer in enlightened jurisdictions?
Well, it's difficult when you can't talk about the medical marijuana card in front of the jury. This is my point. Exactly. Because when you have these laws that are supposed to mean something and you can't take them in front of the jury, it's like there's no balance there. It's just one side dictated. And I know we keep coming back to this, but I can't tell you that I believe that had these cases...
The crucial part of the equation that I think would have balanced out a lot of these situations by now if it weren't for just obstruction on the part of jurisdictions like Oakland County.
Yeah. Guys, I have the actual numbers here for driving under the influence. And it dropped 9% between 2009 and 2010. So that's a very significant drop. 9% drop.
You know what? Back to this, it doesn't. To me, it almost doesn't matter if you amended the law, and I would never agree to this, but it almost doesn't matter so long as you would always have a right to go in front of a jury. You know what I mean? Like if you were guaranteed that right as the initiative stated, the ballot initiative, as it was on the that you would have a right, then we wouldn't even be talking about this because the social change, the change of the officer's mind would happen. but it hasn't happened, and it's been one of the things that's offset the natural progression of the implementation of this act. Do you know what I'm saying about that? I mean that.
I hear you, but how is it addressed? What is the answer?
I don't know. We're lawyers. I thought about that. How do you get? But I think that as a judiciary committee, there's the jury instructions. How about we create a jury instruction for the Michigan Medical Marijuana Act that says this instruction shall be read in every case involving, and we'll just use the language from the referendum. Boom, you have it right there. And then it has to be read in every case. And let the Court of Appeals say that that's not valid. Right?
No,
I'd be fine with that.
Here's another idea: issue a will of the legislature to the judicial, letting them know that this law should be enforced as written and not creatively enforced. Bob and Tori, great example there. These two folks have been in the judicial system for 3 years. They've had multiple trials. They've gone to the appellate, back again. Tori has ovarian cancer, and Bob's all broke up. And the reason they've been in court for 3 years is because the doctor screwed up the certification, and nothing else. The patient did not commit any crime. They were under their weight. They didn't have too many plants. No technical violations. It's because the doctor and the certification. So, this is the biggest problem: is these judges are finding technical violations and then crucifying the patients. And for us as sick people, that's really hard because we can't even afford a jury trial anyway. And that was the idea of the law was to protect us.
Right.
Never been in that situation.
Have you guys thought about waiting until some of these Supreme Court decisions come down? There was just 2 cases that were before the Michigan Supreme Court. One addressing, the unregistered patient issue, and the other one addressing a number of issues, but one including the locked and closed facility, and also whether or not there could be a preclusion, I guess, of the presentation of the Medical Marijuana Act.
That has absolutely been part of the discussion, and I mean that. To me, it's my duty as a legislator to clarify the law and not just leave it to the judicial branch. But there is arguments that just let them have their decision and live with it. I think there's mixed viewpoints on that.
I'm just saying that the timing of things right now. I mean, we have no idea when they may render their opinions on these issues, but some of the things that you are being addressed in these bills, these proposed bills, could be
addressed by the Supreme Court. Representative Walsh last week mentioned Representative Cavanagh that some of the language on locked and closed facilities that was in one of the bills that you were considering, you were thinking just about holding off until the Supreme Court makes a decision on that?
That is absolutely part of the discussion. I don't know how we're going to proceed until I meet with Representative Walsh and Horn next week.